So thank you all for taking the time to join us. This session has been a collaboration between David and Rob and members of our Government and Land Use Committee. And I'd like to recognize the efforts of Susan Eplett, the chair of the committee, Gordon Dorrit, an MLA director and member of the committee, and Debbie Korolnik, also a member of the committee, for organizing the webinar. The purpose of the session today is to provide information on a property owner's rights and responsibilities when it comes to making improvements on your property. We'll not be able to cover all aspects of building and development in this session, but we're starting with small structures, docks, shorelines, landscape, trees, things that are quite frequently looked for in permitting. What you might think that it's your property and you may be able to do what you want, or perhaps you're just making some small changes that you don't think are very significant. But we want you to come away tonight with a better understanding of the rules that apply to these kind of projects and why they may be more important than you realize. There's a lot of reasons to follow the rules. First, you want to be a good neighbor. What you do on your property, your neighbors near or far have to look at, and one wrong move could mean years of altered views. Second, you want to do things in a way that's responsible to the natural environment so that all generations, now and in the future, can enjoy it as much as you do. Sometimes we also refer to this as building back better, meaning if you're updating an existing structure, how can you make it more resilient, more energy efficient, or safer? And if that's not enough rationale for you, you don't want to inadvertently break the rules and then incur fines, work delays, or other penalties, some that could encumber the title to your property for future sale or inheritance. Over the years, more and more rules have been created as we learn the consequences of our actions, big or small. All individuals, as individuals, we may not see the effect of the cumulative effect of lots of small actions taken by many that can add up to changes to our lakes that we really don't want. And unfortunately, many of the rules were the result of something that someone did that caused problems or was unsafe. So let's get going. Here's what's going to happen tonight. I'm going to present 7 questions to our panelists, and each question covering the rules and responsibilities for a typical change that you might want to make to your cottage property. Our 2 panelists will answer the questions, and then we'll be taking questions from the floor, which we also call the Q&A box. And I noticed some of you have already found that. So all of you that are participating with us tonight can submit questions through the Q&A box. So a couple of housekeeping rules. First, all of our participants are muted, so you'll not be able to speak tonight or show us your charming faces on video. You will find the Q&A icon at the bottom of your screen. And if you'd like to ask our panelists a question this evening, please type it in the box and press enter to have it posted. You can enter them at any time through the webinar. If you like a question that someone else has put in, there's no need to repeat it. Just press the thumbs up to like it, and that votes it to the top. And the more votes it gets, it rises up more to the top. So that gives it a greater sense of greater potential to be answered. I would also like to remind you that this is a respectful conversation. David and Rob are here to help us tonight, and I'd ask that you frame all your questions in a respectful way to them. And if we can't get to all the questions, we will endeavor to get answers for you and post them with the webinar when we're finished. As you heard, we are recording it so that it will be available to all afterwards. And to our panelists, just a reminder to use your mute button when you're not speaking. Invariably, the dog barks, the telephone rings, or a child comes in, and that'll keep us from having too many distractions. As I mentioned, the webinar is recorded, and you'll be able to share it with those that weren't able to be here. So let's get started. I'm going to start by introducing our 2 panelists. David Pink has worked for the Township Muskoka Lakes since 2004. He has a degree in biology from the University of Western Ontario and a master's degree in environmental science from Memorial University. David is a registered professional planner in the province of Ontario and is currently the Director of Development Services and Environmental Sustainability for the Township of Muskoka Lakes. Welcome, David. Next, Rob Kennedy. He began his career in bylaw enforcement in 2008 with the Township of Oro-Medonte. He has a Bachelor of Human Services from Georgian College and is a certified municipal law enforcement officer. In May of 2021, Rob joined the Township of Muskoka Lakes as the Chief Bylaw and Property Standards Officer, following progressive positions in the City of Barrie and Tay Township. Welcome, Rob. All right, so we're going to get started with the first of our questions. And this one, we just wanted to give everybody sort of an overview to begin. So the overarching rules. So what are the basic laws, rules, and documents that govern property development and where does the property owner find them, and maybe why do they matter? David, can I ask you to start us off on that?
Sure thing, and thank you, Deb, and welcome everyone. I think it's probably not too appropriate to get into high-level provincial policy and district policy, so I'll try to keep it more of the local context for the purposes of today and very site-specific development. But I will start at the Township official plan, and that is a large overarching policy document that provides high-level direction of the type of development and land use that the municipality envisions. It provides, again, details on the types of land uses we'd like to see and the forms of development that we envision in the township of Muskoka Lakes. But it is not a statute. It is not a law. It's a high-level policy document. But what the municipality must do is pass a zoning bylaw that then conforms and implements that official plan. And it's in that zoning bylaw that I think will be of the most interest today. And I'm happy to respond to questions related to it. And what the zoning bylaw does is provides a zone for every property in the township. And within that zone, you'll find details as to the uses that are permitted to occur on that property and the types of buildings that can be constructed, where they can be constructed on a property, setbacks from lot lines, the maximum density, the maximum permitted heights, everything down to parking requirements. So quite a detailed bylaw, and I'll show some examples of where to find it. And I think some, perhaps some later questions will likely get into how to work with it. But again, it'll provide all those details, everything from permitted uses down to how far a dock can project out into a lake. When it comes to development, that is your principal document. We often get questions in the Development Services Department about what can I do on a property. Your zoning bylaw will likely be the answer the majority of the time. It will dictate, again, what uses are permitted, what can I build, new lot creation requirements. That's often a common question as well. But we do drill down further, and there are other bylaws that are pertinent. And I know Rob will speak to a number of them today, but two in particular that are likely more relevant for today's discussion are the tree preservation bylaw and the site alteration bylaw. And they will apply to all lands, regardless of whether you're undergoing development or not. So the zoning bylaw will apply when you're looking to obtain a building permit and you're looking to construct a building. The tree preservation bylaw and the site alteration bylaw, they apply at all times, and they will dictate or regulate what property owners can and cannot do by way of tree removal and by way of site alteration, or in other words, changing the grade of a property. The last bylaw I'll touch on is the site plan control bylaw, also another important tool in what we call the planning toolbox. But in this case, the bylaw itself is a little less important. The site plan control bylaw largely just dictates which development has to go through that additional planning process before one is able to apply for a building permit. So certain lakes in their entirety are subject to the site plan control process, and certain zones in their entirety are subject to the site plan control process, but there are certain properties that are not. The site plan bylaw also determines what scale of development triggers that process. So even if you are on a certain lake or in a certain zone, if the development that is proposed doesn't exceed a certain threshold, you would not have to obtain site plan approval. But if you do, that is a planning process that has to go through prior to being able to apply for a building permit. And as I said, the site plan control bylaw is a little, I think, again, less important for today's discussion. It dictates which properties are subject to and not. And what I would say is we're currently undergoing a review of our official plan, and which properties are subject to site plan and which are not are currently up for discussion. But I think what is very important through the site plan process is less the bylaw, but more the agreement that comes out of it. So when a property owner applies for site plan approval, the finished product or the site plan approval that emanates is an agreement entered into with the municipality, and it very clearly sets a set of ground rules or delineates a number of measures that that property owner has agreed to when developing their property. Everything from ensuring the lighting on their property is going to be dark sky compliant, to agreeing to put in a sediment fence to prevent erosion and sedimentation of the water body, to where development is proposed, laying out features such as driveways, access pathways, etc. And it is that agreement that's tailored for each property. That's really the important part of the site plan process. And once entered into, a building permit is available to be applied for, and that property owner is then subject to those things that they've agreed to. And it is registered. We typically do register them on title of the land, so they are binding on future owners, not just the current owner. I think, obviously, all of these rules, I believe, are quite important. They set the vision by council for the community, and they make sure that those matters of a provincial or of a municipal interest are addressed. Everything from protecting water quality, really the main goal, protecting the character of our water bodies, and ensuring that the development we see is what we envision for the future of Muskoka Lakes. I will screen share and go through the township website, which hopefully the community will find helpful to how to find these various documents. So hopefully everyone can see my screen. The one, I guess what I'd first state, I did mention the township is currently undergoing an official plan review. So this is our, sort of back up, our homepage, www.muskokalakes.ca. And there's a number of quick links on the bottom. What the community may be interested in, if you select the Engage Muskoka Lakes page, we've created a number of dedicated websites to various projects. And you'll see here, one of the featured projects is the official plan review. So I would say from the forefront, really, as much as Rob and I can talk at length about all the rules today, in planning, everything is a living document, a fluid document, and we're currently undergoing reviews to the tree bylaw, the site alteration bylaw, and the official plan. And you will see a dedicated page here to the site alteration and tree preservation bylaw review. And here's the official plan review. So what we're talking about today are certainly the rules as they are in place today, but they are subject to change. So it's always good to confer with the municipality or check our website for the latest set of regulations. So what's helpful, if you do go to the dedicated page, you can subscribe by registering on the webpage, and then you will be provided with updates as the municipality moves through this project, and more significant notable touch points where the community can provide their input. And there's often online surveys and various documents, project timelines. So I thought that was helpful to point out. What we can go to next, if you go back to the homepage and just highlight Township Hall, you'll see bylaws and policies. If you select that link, a number of bylaws and policies will come up. And again, the ones I believe we will be talking about today are the comprehensive zoning bylaw, as well as the tree preservation bylaw, site alteration bylaw, and the site plan control bylaw. So that is the quickest and easiest way on our township website to find those documents. And answers the question, and you find that helpful.
That's great, David. I think that's I'm going to say that you've done some improvements to the website since I was last noodling around on it. So nice job. Great. Anything you want to add, Rob, to that before we move on to our next question?
No, I think that was pretty thorough.
All right, great. So the next one we want to get into is waterfront. Obviously our waterfronts are our main reason for owning a cottage, and I don't know about you guys, but it's where I spend the majority of my time. So there's tremendous pressure though to make it fit all the needs that we have, whether it's additional boats, whether it's amenity areas. So even though I think of the waterfront is mine, what can I actually do there that I don't have to seek permit for? Can I add a beach? Can I fix up some erosion? Can I have a hot tub on my dock or a fire pit? I don't know. Rob, do you want to start us off with this?
Sure. With respect to waterfront, there is one delineation that I do want to make quite clear, is that the township bylaws are only for township land. So any work that a property owner wants to do that ends up going into the actual water body, different agencies, mainly the provincial agencies, are the ones that would handle those types of situations. So if you have, say, a weedy front area at the water and you want to take those weeds out, or there's some dead wood that's in there, and you kind of want to clean up that lake bed, you would go to the Ministry of Natural Resources and get what's called a shoreline work permit. You would apply for something like that, and that's the agency that would deal with in-water works. So the relation to that in the municipality is those provincial agencies will contact our planning department and ask for comments on regards to what the work is doing. With our tree preservation and site alteration bylaws, the one main prohibition in both bylaws is that no one shall alter the grade or remove any tree within 50 feet of the water. So we more often than not would comment that we don't want that stuff to happen that's in the water, because 9 times out of 10, if someone is doing something in the water, it's probably going to be also being done on the shoreline. So again, with the site alteration bylaw and the tree preservation bylaw, the first 50 feet is a relative no-go. Now, there are certain exceptions to those. First, I'll talk about the tree preservation bylaw. There's a bunch of exceptions that you can have where you don't necessarily need a permit. You don't need our permission to do, even though we do appreciate the call. If you have a dead or decayed tree, or if there's one dangerous that's broken halfway up, it's leaning over the cottage or an accessory building, you don't have to have permission from us, and you don't have to have a permit for that, as it falls under those exemptions. So you can do that at will. Just make sure that a lot of times we do get it in our enforcement, regardless if the tree is dead or decayed. More often than not, we will get called for. So don't be surprised if we do show up to the property while you're doing the work or shortly thereafter. And 9 times out of 10, everything's fine. We just have a chat, just educate a little bit, and go on from there.
Rob, we'll have more on trees shortly. So maybe could you maybe focus a little more right on the shoreline itself and things that people can do or not do, perhaps is yeah.
So with the shoreline works and the waterfront, if you're looking to add a beach, it's a no. We don't allow a sand to come into areas. There's a lot of places that have natural sand that you're allowed to have, but we like to keep that shoreline as natural as possible. So no one should be putting any artificial rocks, sands, that kind of material onto the shoreline to alter the grade. Once you've altered the grade, you'd be in contravention of what our site alteration bylaw would be. And just give me a second here. Again, if you're looking at, say you want to build a stone wall across your shoreline, again, within 50 feet of the water, we would say no. We can understand that if there is natural rocks on the shoreline and you're looking, say there's some that are cracked or deteriorated and you want to replace those, we can understand that you want to replace those and make sure that the erosion isn't going to happen any further than what it might have already. But if you're looking to build a rock wall along the waterfront, we would prohibit that through our bylaws. And again, if you're looking to do something in the water, we would then forward you on to the provincial agencies that would deal with something like that. Other things that people like to build, gazebos, stone patios, wooden decks. The zoning bylaw, as David said, there are certain setbacks to those types of things. If you wish to build a gazebo, you can build it as close to 3 feet from the high water mark. Sun decks, which, the wooden decks, they would have to be at least 50 feet back from the high water mark. So if you are a property owner and you're not clear on what those setbacks are, we always encourage you to take a look through the zoning bylaw. I know it is a little bit of a difficult read, but take a look through that and see if you can clear that up through the bylaw. If you still have questions, by all means, the bylaw enforcement isn't just around to deal with complaints. We also answer a ton of inquiries. So if you have a question in regards to a setback, you can call us, you can email us at the bylaw email, which is bylaw@muskokalakes.ca, pretty generic. And you can also contact the planning department for those types of things. But I think I'm fairly well versed on the zoning bylaw by now that I could most likely get those questions to you in a good, timely manner.
Great, thanks, Rob. David, did you want to add anything to that?
Thank you, Deb. Just on a high level, obviously being more involved in the official plan, I think the overarching message that we try to get across is the goals of the municipality is to keep your shoreline as natural as possible. Really, I think why we all come here and we enjoy coming to Muskoka and enjoy our cottages to look out and see trees and rocks and the natural landscape. And the official plan really strives for that goal, is that the built form does not dominate the shoreline. And that's why our official plan and our zoning bylaw subject buildings to setbacks. So they're set back from the water, and then that first 50 or 66 feet, what we call the shoreline buffer or the ribbon of life, is really kept as natural as possible, so that all that vegetation can prevent against erosion. What happens when vegetation is removed? It doesn't, the soils are no longer stabilized, and during rain events, a lot of those soils can enter the water body, including any pollutants or nutrients that come with it. And the vegetation not only stabilizes the soils, but also absorbs nutrients and pollutants. So it's very important that that area is kept natural. And that's really the goal, the overarching message of the official plan. And then you'll see that as a reoccurring theme in these documents that we're talking about, the zoning bylaw, the tree bylaw, and the site bylaw. So they each allow some, very modest permissions within. As Rob said, you can have a small gazebo. Through the site plan process, we certainly allow property owners to construct pathways down to the lake and things of that nature. But we do want to keep that area natural. And as much, I also don't want to encourage a flood of applications to the provincial ministry on altering in the water. I think, again, as Rob said, they will contact the municipality for our comments. And if a property owner is just looking to remove vegetation from the shoreline or build a shore wall, we will look to our official plan, and our comments to the province will likely be we wouldn't support it. So I wouldn't spend too much time looking for those types of projects. I think where we may be able to support some work in water is when there's an existing structure feature and someone's looking to restore it or rehabilitate it. We certainly will consider that. But again, I think it's important to send home that really overarching message of really along that shoreline, let's keep it natural. It's for the benefit of everyone. It's to protect the water quality and really why we're here. So that's really the reasons for these documents.
That's great. And certainly the MLA has supported the view that the municipality has in terms of, and I don't think you've used the word environment first, but it's essentially what we're, the way the plan's reading at this point is in terms of suggesting that we have to do everything with an environmental lens, or we won't have the lakes that we deserve and desire. So, great. Well, let's move on to the next question. We're going to talk about docks next. So if you're like me, I live on the dock during the summer. Every cottage has one. I don't think I've seen two that are the same, but of course they take the brunt of the weather, ice jam or ice damage, flood damage we've had in ours. And so we need to do some TLC on them every so often. So where do I start to learn what I can and can't do with my dock? And who wants to start this one?
I can take this one, Deb, and I think what I would say from the forefront, I noticed in the initial poll that there's a number of people from Bracebridge, Gravenhurst, or Seguin that are not in the township, so please keep in mind each municipality has a different set of rules, so this is pertinent to the Township of Muskoka Lakes. And I'm happy to run through sort of some hypothetical or high-level type of situations, but just keep in mind that every property is unique and some properties may be undersized, maybe subject to different zones. But I can quickly go through the zoning bylaw, and I like to think it is a meaty document, but we try to set it up as user-friendly as possible. And I think with a little bit of knowledge or information, most property owners, again, with this brief presentation, hopefully find it a little bit easier to work through and see what they can do. So really the very first important step is knowing what the zoning bylaw will allow you to construct. That's always the very first step. And if you can't comply with that zoning bylaw, there's always an ability to reach out to the planning department and inquire. The province does allow property owners to apply for, it's referred to as a minor variance or a zoning bylaw amendment. So zoning bylaw may say you can only build so wide or so far out or such a large dock. If you can't comply with those rules for whatever reason, you can apply for relief from them, and the planning department can assist you as to what the policies say and what the likelihood of that approval is before you go too far down that path. But again, the first really best place to start is our zoning bylaw. So if I can screen share again, I'll work through that document. Hopefully that makes it a little bit easier. So again, we went to the bylaws and policy page, and it's the comprehensive zoning bylaw that is of interest. And again, what I'll refer to is what will apply 80–90% of the time, which is waterfront residential zones. And the way our zoning bylaw is structured, after general provisions, which I just quickly scroll through, those apply to all properties, you will see the waterfront residential section. So there are different zones: waterfront residential, waterfront.
Make that a little bigger, David. Can you perfect, great. Yeah,
there are community residential zones, community commercial, community industrial, rural, etc. But again, I believe most of the audience is likely zoned waterfront residential. So the first chart is not applicable to this question, but the first really main chart in this section will dictate what you can do on land. So for those structures on land, what the setback is from the water, the lot coverage or density, heights, setbacks from neighbors, etc. But in respect to docks, if you scroll down to section 417, which is accessory structures over water, you will find this table, table 417, and it's broken down in two respects. One, based on the amount of frontage that the property has, and you'll see at the very top row, up to 200 feet of frontage, 200 to 300 feet of frontage, and if you scroll down to the next page, 300 to 400 feet of frontage, and 400 feet or more. So that's your first distinction, and property owner will have to determine how much frontage they have. And to dive down in a little bit of the weeds, our zoning bylaw will use a straight line measurement. So not necessarily what you see on your tax bill, but typically fairly close. And then the next row, our next question to put you into the right column, is the category of lake. And you'll see categories 1 through 4. So in each amount of frontage, up to 200 feet, 200 to 300 feet, you'll see categories 1 to 4. There is, and pardon my fast scrolling, but at the end of this section, you will see table 1, which lists all of the lakes in the township and what category. It's quite easy to remember. The large 3 lakes are in category 1. That's your big 3, Rosso, Joe, and Muskoka. So we'll use that as our base example. So I'm a property owner. I have 150 feet of frontage, and I'm on Lake Muskoka. So I will fall into this category 200 feet, category 1, and you can simply go down the chart, down the column. Docks are first, and the maximum length that I can project out into the lake, the maximum width that I'm permitted. This is again of your frontage, and the setbacks from my neighboring property. What's important to know, and a lot of people aren't aware of this, these Township Muskoka Lakes does not regulate the amount of docks permitted on a property. You could technically have 5, 10 docks, but cumulatively, if you add them up, the width of them, they can't exceed 25% of your frontage. So perhaps to make my math a little bit easier on myself, if we took a 100-foot property, I can have 25 feet of dock across my frontage. I could choose to build one 25-foot wide dock, or I could choose to build 2 12-foot docks. They can both go out into the lake 66 feet from the shore. Setbacks from the neighbors, fairly self-explanatory. Then your next column is boathouses. And again, I know the question was about docks, but you can go down and learn about the rules for boathouses, how much frontage I need for a 2-story boathouse, how wide, how high can that boathouse be, and setbacks from the neighbors. And of course, what always makes planning quite difficult and the zoning bylaw is there's always exceptions to the rule or further explanations or caveats needed. So after the chart, you'll see footnotes 1 through 18, and you can go through those footnotes, and they either provide a bit more information or some refinement to those rules up above in the chart. So that is your first step to determine what can I do. And again, if you fall within those rules, great. Your next step would then be to apply for the building permit. Same department, just different division. We have building department staff. And again, on our website, details about how to apply for that building permit and all the various documents you need. If in doubt, always best to reach out to them to determine when you do and do not need a permit. But essentially any dock will need a building permit if it exceeds 108 square feet. That's 10 square meters. It likely will require a permit. It's becoming more rare to require a land use permit from the Ministry of Natural Resources and Forestry. You need to exceed a certain square footage of the lake bed, or to occupy a certain square footage of the lake bed to require an MNRF approval prior to obtaining a building permit with the township. It's currently, I believe it's 15 square meters or 160 square feet. And we typically only see that now with crib dock construction, which is becoming, appears to be a little less prevalent. So once you determine what you can build, you then apply for that building permit, provided all the appropriate documents are submitted and drawings. Typically will take 10 business days or less to obtain that building permit. Again, anything over 108 square feet will likely trigger that need. Won't require it, likely in the case of general repairs. If you're just changing the deck boards, that can be done without permits. But if you're doing any type of structural elements of that dock, again, you will likely need a building permit. We often get the question whether rules are any different for floating docks or permanent structures. They're not. Our zoning bylaw defines a structure, and it is a very all-encompassing, I will say, type of definition. And we can and have argued that really anything that has a sense of permanency to it will fall under the definition of structure. And that would mean even if you repeatedly put it out there only on a seasonal basis, that floating dock structure we've long held does require a permit and does need to comply with our zoning bylaw. So floating dock, all the rules are the same, whether it's crib construction, steel pile, floating, etc. I think the last thing that the community may find helpful, because this is a common question, are in regard to boat lifts and temporary type canvas boat covering. You may not need a building permit for those structures. But it is a very common misconception, and I probably can't repeat this enough today. Even if you don't need a building permit, whatever you place on your property still needs to comply with the zoning bylaw or other applicable legislation. And there's I believe, a fairly common misconception in the community that if I don't need a building permit, I can essentially do what I want. And I can put in boat lifts, boat covers, those types of amenity type features. Our zoning bylaw does actually include those in the definition of docks or boat ports, and they will count towards those rules. And again, just because you're under 108 square feet or may not require a building permit, it still needs to comply with the zoning bylaw. So very important to know. Hopefully that provides a good overview of what you can and cannot do with docks, but happy to provide any follow-up if there is.
That's a great overview. I know there's some questions in the Q&A, and just a reminder, everyone, go to the Q&A box for putting your comments or questions in, and we're both answering them live as we go, and some of them are being answered through by our panelists who are I see some of them being answered as we go along. But all right, so next thing up, we want to talk about landscape, and we started to get into this a little bit earlier, but we've all heard about some pretty drastic changes that have been happening to landscapes on some Muskoka properties. And by landscape, I mean the rocks, rock outcrops, trees, other vegetation, and the slopes. So maybe trying to make it less slopey on the property, so easier to build on. So the landscape on our properties is really an essential part of our waterfront living and the natural environment as well. And it serves a function, as David was mentioning earlier, in terms of absorption of water and absorption of nutrients and habitat for wildlife. So, so even though we own it, how much can we change even when we're not building anything? So that kind of comes, we're going to talk about trees specifically next, but where do we find the rules about making changes to my property? I want to change my driveway. I want to change, I need to blast a rock away so I can, I need to maybe to provide better access or to build my septic system or things like that. So can you give us some sense of that? I don't know who wants to start us off, whether it's David or Rob on that one.
I can go on that one. So specific to landscaping, we have, again, our site alteration bylaw, which I will pull up here. So if everybody can see that, this is in our site alteration bylaw. First and foremost, if you are doing any works on your property, this bylaw only pertains to the high water mark to 200 feet away from that high water mark. So if you're in the rural area, you're not close to any of the lakes, this bylaw does not apply. Within the 200 feet is where this bylaw now comes into effect. And a lot of times this bylaw is dealt with in conjunction with either a site plan agreement or a building permit, a septic permit. So not often do we get situations where there is nothing like that attached to an enforcement issue, but if you're not building anything per se, if you're not building a house, building a dwelling, building a boathouse, and it's within 200 feet, you would need a site alteration permit. And to get to those permits, on our website, if you go to our permits, if you search permits at the top of the website in the search bar, you'll get I'll see if I can do it here.
While you're doing that, there is a question about how one determines the high water mark. It might help people understand a little bit more about where we're talking about.
I can quickly answer that. That's more planning related. The zoning bylaw does define high water mark, and it's that present normal water edge. So it will fluctuate seasonally, but there are controlled levels, and surveyors are well attuned to determine precisely where that high water mark is. We do generally encourage surveys prior to any development, as they're really the only way to know for certain where that is, what the size of your property is, what the size of your buildings are, to ensure that you're actually building in compliance.
We're not using the floodline mapping that the district has done as that elevation?
There are various sources or mapping that may delineate where the shoreline is. However, when obtaining a building permit or going through a planning process or planning application, we need proper, clear, accurate to-scale drawings of your very specific property delineating where that water's edge is, so that we can ensure you meet the requirements before any permit is issued or planning approval is given. And when you build, there are various inspections through the building process, and a building inspector will need lot lines flagged in order to take measurements to ensure you're then building in accordance with your drawings. So again, that's where a survey is very useful, so that you don't run into trouble down the road trying to do your own drawings or estimate where these important lines are.
Absolutely. Sorry, Rob, I took us off track there for a second, but go ahead.
That's okay. So yeah, back to where you can find applications. If you search permits, you'll come to this page, applications, licenses, and permits. Then you'll go down to the planning, and it'll be another drop down with all these different ones. You're going to the other planning applications, and here you'll see the site alteration permit, and then you'll also see the injured or damaged trees permit, which we'll get into in a bit. So those permits are for if you aren't building anything really, and you just want to alter your landscape in any which way that would alter the grade. This is where you would go to get one of those permits. Again, we don't see that very often, because a lot of times the landscape is built in with the building permit, or not actually. A lot of the time it's built in with the site plan agreement. So that being said, within the first 50 feet, unless otherwise found in the exemptions, which again, I will go back to the site alteration bylaw. So actually, sorry, I'll just back up a sec. So in section 2, the land subject to this bylaw, as I said earlier, all lands within 200 feet, all land that's within the waterfront designation. So as David was saying earlier, with the waterfront community designations, the waterfront residential designations, that's where this falls under. For the community designations, which are found, in the actual towns, Bala and Port Carling, all lands within 25 feet of a navigable waterway. And then, as I'm sure of more of a common sense thing, anything in the environmental protection area, that's where it applies. And also land zoned in the scenic corridor, which is mainly along the highways that are in town. So again, back to the exemptions. As we see, there's a lot of things that are exempt. These are more or less just there due to being in what's called the Municipal Act, where we gain our authority to actually make bylaws. But if we go down to most of the bottom ones, there's exemptions that you can build temporary access roads for island properties or properties that are only accessible by water. Stuff like that is exempt through the bylaw. Again, as David said, this is subject to change. So there are a couple more exemptions that we have proposed in our new draft site alteration bylaw, which can be found on our website on the Engage Muskoka Lakes page that David had shown everybody earlier. But with anything within 200 feet of the water, you would need a permit for something like that. If it's within the 50-foot mark, more than likely we would not support it. So you can apply for it, but with the prohibition that we have, it would more than likely be denied. But again, anything that we have, for a lot of the stuff that we have, is usually through the building permit process or through the site plan agreement process, which is falling under the exemptions. So that's where most of this stuff comes into play.
So just there was a question in the Q&A, but what happens outside 200? I'm assuming that basically you are have a little more free reign to you don't have to go with the bylaw.
Correct. Yeah. So again, all lands within 200 feet of the navigable waterway is where this bylaw stops. So once you go beyond the 200 feet, There is no permit process. Essentially, you can do whatever you please on your property.
Having said that, we want to make sure that we do it with a sensitivity to the value of that land.
Yeah, and regardless, they still have, like, people still have to follow zoning bylaws and follow the other bylaws that we have in the township. It's not like a free willy-nilly type of thing after 200 feet. But you know, this bylaw doesn't apply, and same with the tree preservation bylaw; those don't apply after 200 feet.
Okay.
At
Great.
this.
Okay. Go ahead, David. Yeah.
If I could add to that, Deb, I don't want to imply as if it's completely free reign. As Rob said, there are other bylaws, but typically what you will see too, a lot of property owners are now subject to a site plan agreement. As time goes on, more and more properties are subject to that, and that will apply to the whole of lands, not just to the 200 feet. Staff typically do concentrate on the shoreline. That's the most prominent area. However, the agreements will not allow tree removal outside of building footprints or envelopes, so even beyond 200 feet.
Great. All right. Well, speaking of trees, let's do a little bit more in depth in trees. So they're part of the lot, and I will readily admit I've taken down a few that were hanging on the power lines and a little too close to the cottage, and they had so many woodpecker holes in them that they weren't going to stand another year. But so what should we be doing about our trees? We want to manage them, but do we want to have to get permits every time we want to take down a tree that is diseased? What kind of rules around the trees should we be following?
I could do this one again. So for trees, a little bit different. Again, with our bylaw, oops, sorry, I will screen share again. So if we go to our tree preservation bylaw, which is very, very similar to site alteration when it comes to the lands and the exemptions. So again, if we go down to section 2, lands subject to the bylaw are the exact same as what site alteration is. So anything beyond 200 feet, this bylaw doesn't apply. Anything within 50 feet of the water, again, we do not allow something like that, but we do have the exemption. So as Deb just said, if you have a decayed or diseased tree, if it's dangerous, if it's broken, you are allowed to remove it regardless of where it is on the property without a permit. But again, we do, as enforcement, to kind of make our jobs a little bit easier and to also make property owners' jobs a little bit easier, we do appreciate a quick email or a phone call just to say, hey guys, we're removing a couple trees. They're dead. They're a danger to our cottage, our boathouse. Just this is our address. This is when we're doing it. And honestly, we really do appreciate that because, as I said earlier, a lot of times, regardless, we're still going to get a call about it, and we're always going to show up. So if we get that phone call before you guys actually do stuff, it makes our job a lot easier. And if we get a photo or if we get photos of the trees you're taking down, all the better. So specifically, the exemption for the dead and dangerous is here, section 3J, removal of dead, dangerous, disease, or severely injured trees or stumps in accordance with good forestry practice. That's where that exemption falls under. If you want to take any live healthy trees out, that's within 200 feet and outside of 50 feet, that's where you would need the permit. Again, a lot of these fall under the building permit process a lot of times because obviously if you're building a dwelling, you're going to have to take trees down if it's a forested lot. The building permit allows that exemption. Also 15 feet of a buffer, and a good photo to show you for a buffer is this here. So this is a building site. Again, we got a call for it. People thought that they were taking too many trees down or doing too much site alteration. So
we're not seeing that yet, Rob. I think you have to stop sharing the bylaw one and then try it again.
Let's see what we got here. Can we see that?
Yes.
Okay, perfect. So this building site, obviously, this is where the building is going, where the pit is. And then you have it's actually probably less than 15 feet from where these trees are. They did obviously have to take down a few that were just inside this buffer area, but this is a type of property that there is no contravention to our bylaws, regardless if it was 50 feet within the shoreline. And again, I believe this is the same property here. Yes, so this is the same property just behind us. This is the shoreline that they've left. There's a boathouse that's going to be going on the far side. They've cut a small path that goes down to that boathouse and left all this untouched. This is what we like to see when we go to properties, regardless if it's a complaint or not. This is a perfect example of what we're looking for.
Great.
So
Thank you.
yeah, and I guess other than that, pruning is another big issue that we have within this township. It's a little bit difficult because if branches are dead, which we do see quite a lot on the white pines in this area, a lot of people unfortunately like to take all those all the way up to the top, what we like to call, make them what we like to call a Muskoka palm tree. So we have, oh, sorry, I got a screen share again. We have pine trees that a lot of times can look like this. A lot of times the branches on the understory are dead. They don't have anything there and people want to take them out. A lot of times it's to get a better view of that lake. We don't necessarily like to see that, especially if these, obviously if the branches are healthy, it's a violation to our tree preservation bylaw. But people do take these trees and then they turn them into something that looks like this. Can we see that one, Deb?
No, not yet.
Okay. So if we go back, so people will turn them into something that looks like this.
Oh, you're right.
So that's not what we like to see in the township. We want to make sure that, again, that the shoreline is kept to a natural, oops, there we go. The shoreline is kept to, you know, a natural state as best as possible. So that type of stuff isn't really what we like to see. Again, there is an exemption built under if the branches are dead, yes, they are allowed to cut them. If they're a safety issue, yes, you can cut them. But we are working on some things in our new draft tree preservation bylaw that will either prohibit it or at least make it a little bit more difficult and give us a little bit more oversight so we don't keep seeing these Muskoka palm trees all over the township.
And can you retroactively enforce any removals or damage to trees?
If we get a complaint a couple days after it's happened, you know, the cuts are relatively easy to find. You know, stumps that are freshly cut, it's still easy enough for us to identify. So retroactively we can, under the Municipal Act, if we want to lay a charge for something like this, excuse me, we have 6 months from the time that we saw the violation. So just keep that in mind. If someone's cut trees down, you know, don't wait 3 months to give us a call. Try to give us a call as soon as possible. If we're not in the office, be sure that we will attend to that property as soon as we're back in. Starting, I believe, in, what day is it now? The 19th. So probably in about 3 or 4 weeks, closer to May 2-4, we will have enforcement staff on weekends. So people are more than welcome to email us or give us a call on the weekends, and we can send an officer out as soon as possible to get out to those places, hopefully while the cutting or in another case, if the site alteration is happening, we can get out there while it's being done and stop it before it gets even worse.
Great, thank you. We're going to move along. We've got two more questions that we want to get to. One is bunkies and sleeping cabins. I know there's been a run on those. I think some people are using them as offices, of course, as they move to the cottage for pandemic. But so in Ontario, a building less than 108 square feet doesn't require a building permit. So the bunkies become a fairly simple way of adding some additional cottage capacity. But what are the rules for bunkies? David, do you want to start there?
Sure. Again, the rules for that type of development will be found in your zoning bylaw. So again, go to the zone, the applicable zone. Waterfront residential is the prominent zone that will allow sleeping cabins. And the key overriding factor or message is our zoning bylaw only allows one sleeping cabin per property. And the zoning bylaw is very clear that any type of habitable room will constitute the bunkie or the sleeping cabin on that property. So we often get questions, I just want to put in a gym or an office or an art studio. Any of those potentially would be permitted, but that will be the bunkie or the sleeping cabin on the property. So you are only permitted one. Again, as I said previously, even if you don't need a building permit because it's under 108 square feet, the zoning bylaw still will say you're only allowed one sleeping cabin on the property. So it's not as though you can obtain a building permit for the one larger bunkie and then put up endless 108 square foot bunkies. You are only permitted one, whether you need the building permit or not. Again, you will need it if it's, again, over 108 square feet. If there's any plumbing involved, you will also need a building permit in that situation, regardless of size. When it comes to the parameters, we do allow up to 650 square feet is the maximum size for a sleeping cabin. Subject to the same rules as other buildings on land, 66 feet back from the water is your typical setback, 15 feet from your neighbors is the typical setback, and it does need to comply with the lot coverage or density limitations of your property as well, because it will have a roof. The other very common question we get is what type of facilities are allowed in the sleeping cabin. The key distinction between a sleeping cabin and the main residence is the cooking facility or kitchen. So you're not permitted a cooking facility, which would presumably then allow a family or individuals to reside in that bunkie on a long-term basis. So no stove or oven. However, you can have plumbing, you can have a washroom, potentially sink, wet bar, separate rooms, permitted again for overnight accommodation, but the premise is meant for typically overflow or temporary type accommodation, again without a kitchen, not intended for long-term use, but you can obviously improve it to quite a nice state with plumbing and those types of features, just no kitchen.
Great, thank you. And along the same lines, of course, there's other ancillary buildings that people want to have with the property. And as more and more people are moving up to their, what was the cottage, and they're now living there permanently or living there longer, there's, I think, been a greater desire for additional accessory buildings. So can you tell us, what do you consider an accessory building? And then what about some of the rules around those? So a garage or I don't know, a sauna, other things like that. So.
Mm-hmm. Certainly. So unlike sleeping cabins and dwellings, which the zoning bylaw and official plan clearly state you can only have one of each. And again, I'm referring to the general waterfront residential zone property, because that's what we are dealing with 90% of the time. You can, unlike those, which only limit one, accessory buildings are like docks that I spoke to earlier. Technically, the zoning bylaw does not limit the number, provided it's an accessory to your residential use. So there is technically no current limit on the number of garages, the number of storage sheds, the number of gazebos, the number of saunas that one wants to put on their property, provided they comply, again, with the zoning bylaw, building permit or not. Typically, most properties, the limiting factor will be density or lot coverage. We only permit a certain percentage of the property to contain roofed buildings. Depends again on the zone and the lake. And most property owners or properties, once they construct a cottage, sleeping cabin, the boathouse, typically there's limited room left to then construct endless accessory buildings. But currently, provided it is, we view it as accessory to the main use, there's no limit on the amount. or technically the size. One could technically, under the current rules, have a larger garage than the cottage, provided it is again used for that accessory non-habitable purpose. That is the key distinction. Again,
So what if we wanted to put a second story on a garage and have sleeping in there? Does that count as a sleeping cabin, or does it count as a garage with benefits?
It would count as a sleeping cabin, and it is permitted. We do get many garages, two-story garages with sleeping cabins above. It's quite a common type of development, and it is permitted, provided the sleeping cabin above is under 650 square feet and is the only sleeping cabin on the property. So again, if there's already a sleeping cabin above the boathouse or another sleeping cabin or bunkie on the land, that would then prohibit a second sleeping cabin above the garage, but that can be your sole. And just quickly, I did want to mention that as with anything, bylaws are always under review. We're going through an official plan review and also a zoning exercise to look at our rules around accessory buildings. I think currently the Township of Muskoka Lakes does not quite provide as many details around accessory buildings in our zoning bylaws. Some of our neighbors do, and council is currently looking at potentially controlling the number or the size of accessory buildings. So for now, what I've talked about are the rules as they are today, but there is another one of those engage pages. If you want to find that project page and subscribe to that, you can follow the latest on that project.
Great, thank you. Anything you want to add, Rob? We're going to move into the open question period at this point, unless you want to say anything before we do
no, nothing specific to the accessory buildings. I could speak a little bit on our enforcement process if you'd like, just in regards to tree and site alteration.
Sure, go ahead.
So with tree preservation and site alteration, there's a certain enforcement process that we have available to us through the bylaws. So when we receive a complaint and we confirm that there's a violation under either bylaw, we have the ability to issue an order to comply or an order to remedy. And in that order to remedy, we can realistically have an owner do a number of things. The main one that we do is something to rehabilitate the land. So a lot of times we will be asking for an environmental consultant to come onto the property, evaluate what's happened, and then do a report for a revegetation or rehabilitation on the property. And then that report is then built into that order, which the owner has to follow. And there's certain timelines that are built into that. Timelines on the order itself are set in stone. Obviously, as officers, we always have our discretion. So if there's going to be a certain situation where, sorry if you can hear my kid in the back, but there's certain situations where we can grant extensions if we feel that it's necessary. A lot of times, we'll get into the winter months where planting trees in November probably isn't a great idea. So we have to put it on hold until the springtime and have those planted. We have situations like that all the time. I'm dealing with a few already in my first year. So with those rehabilitation plans, if a property owner does not follow it, then they are subject to a couple things. One, we can charge. And again, we have up to 6 months to charge from the date of the offense. So if we want to charge specifically for, say, a property that has done site alteration within 50 feet of the high water mark, we have 6 months from the time we visited the property to do that. But if we lay the order on the property and we give them a time frame of, say, 3 or 4 months to get that stuff into us, if they don't comply by that deadline that's on that order, that is when that contravention has occurred. So we have from, say we give a deadline of today, of April 19th, we have until today to 6 months from now to lay a charge, which would be a fail to comply with an order. So that's one option that we have. Another option that we have is the township does have the ability to take that rehabilitation plan and we can implement it ourselves on that property. It's not really the route that we want to take, but it is available to us. I would say more often than not, we do get compliance from the property owner after we've issued the order. Yes, we do lay charges on some cases, as we've obviously seen in the news in the last year. But a lot of times we do have the owner comply and follow what we've actually asked them to do. Another order that we can lay is a stop work order, self-explanatory. We get to a property, we find a violation, we can cease that work immediately. If they don't want to follow that stop work order, again, charges can be laid, and we go through that whole process in court again. And if people want to see what the draft tree preservation and site alteration bylaws are doing in regards to offenses and penalties, again, more than welcome to take a look at that Engage page. We have, right now, our maximum penalty is $10,000. We have upped that to the maximum allowable through the Municipal Act of $100,000 per offense. That being said, the court of law, on a first offense, you don't necessarily get something that high. Those are mainly for the concurrent offenses or the secondary and on offenses for a property owner that does something like that. But if we have $100,000 available to us, we can obviously get more than what the maximum would be if we only had 10. So that's a big improvement for us. But I want to make it quite clear, as that has been a misconception with a lot of people I've talked to, is that we can't go above and beyond $100,000. That is built into the Municipal Act. There is nothing that a municipality can do to get more than that on a penalty. We've also implemented what are called set fines within the new bylaws. So if and when those are passed, those will allow us for more of the minor offenses. If someone puts a couple loads of sand and they make a little beach, we can obviously issue the order, and we can, instead of dragging a person into court for something like that, and keeping the court for more egregious offenses, we can issue pretty much a ticket. Same thing as you would see if you got stopped by the police and you get a ticket on the roadside. It's the exact same piece of paper. The draft bylaws would give us that ability to issue something like that and make it a little bit more of a streamlined process and give us another tool in the toolbox for enforcement.
That's great. Thank you for explaining all that. And I think it just goes to say that maybe you better look at the rules first, because you don't want to get embroiled in this. And that's where we talked at the beginning about project delays and added expense potentially. So it's wise to be upfront. So on that note, I think just one of the quick questions I think we kind of touched on earlier on is, if I want to find out, do I need to do something? Where am I going to come? Is there a planning counter? Do I need an appointment? Are you even open now? David, can you tell me how we would do that?
Yes, thank you, Deb. We are open to the public. I forget now exactly, but it's been more than a few weeks, so we have opened our doors fully. With that said, our department, the various arms, are quite inundated with applications and building permits, etc. And it is challenging to respond promptly to every very general type inquiry. If a property owner or member of the public is looking for some basic information, picking up an application form, asking about fees, scheduling, that type of information, or as Rob said, has some general questions about bylaw enforcement matters, certainly we should be able to accommodate them on a drop-in type basis. If a property owner is looking to develop their property and may need a planning application and wants to sit down with a planner and go over, very specifically what they can do, a pre-consultation on an application, we highly recommend that they contact our office and schedule an appointment. And unfortunately, again, maybe a little bit of time before we can accommodate that, but we are trying our best to get to everybody, and we would encourage again, booking appointments for those types of inquiries. Dropping off a building permit, you can come and simply do that. You don't need an appointment. There is a counter to drop off building permits. And
when we finish tonight, there'll be the planning connection or planning email will be on the resources slide at the very end. So I've got a couple of questions from the the Q&A. And one just sort of comes to a little bit of what Rob was just talking about. Why do complainants have to identify themselves? Because a lot of people, I think, want to do it anonymously so that they don't pit neighbors against neighbors. And so I'm gathering that's correct. You have to identify yourself to the neighbor if you were the complainant.
This again, I think, is a little bit of a misconception. And fair enough. People don't necessarily know certain statutes and whatnot. So when we receive a complaint, we would need that person's information. And first and foremost, we don't release that information to the property that we're going to. We have an act that the municipality has to follow. It's a little bit of a tongue twister called the Municipal Freedom of Information and Protection to Privacy Act. So for short, we call it MFIPA. So we have to follow that. And when someone makes a complaint, we do take that information, we log it into our systems, and that is not released to anybody other than the officers. Could be from David if he wants to take a look at the file, and other people that would be involved in the case. It doesn't get released out to the public. It doesn't get released to the complainant. We get it all the time. When we get to a property, who's the one that complained? Sorry, we can't tell you. And a lot of times we get people that will assume. And my one-line spiel for that is don't assume, because if you do and you pick the wrong person, you dig a deeper hole for yourself. So the reason that we ask for the information is because municipalities historically have found an issue with anonymous complaints, because a lot of times the anonymous complaints turn out to be nothing. And in the past, a lot of municipalities have dealt with that, where they continually go to a property on anonymous complaints. There's nothing wrong, and people essentially use bylaw enforcement as a harassment tool against their neighbors because they don't like each other. So that's where we try to curb that act and get that information out. But again, when people complain, rest assured that we do not release it to the public. The only actual time that any information would be released is in a court of law. If we needed that person to attend for court to give evidence, then that's where that person would end up having to at least show their face and say who they are. And there are certain situations in bylaw enforcement that we need that person to be there for evidence. Not so much for tree preservation and site alteration issues, but for other issues, say for a dog at large. If we don't see that dog off the property and that person that calls and complains does, we would need that person to give us that evidence if anything ever went to court, if we charge someone. So we can't lay a charge if we don't have evidence. So that's another big reason why we need that person's information. But unless it's a very, very serious health and safety hazard, we don't necessarily act on anonymous complaints.
Okay, good, thank you. There's a question that a few people have thumbed up. Do I need a permit to place a Shelter Logic style portable garage on my property?
I think I'll try to handle that one, and keep in mind I'm not a qualified building inspector. I'm not necessarily an expert on the interior building code, but I don't believe you would need a building permit for that type of structure. However, as I said repeatedly throughout, keep in mind it still needs to comply with the zoning bylaws. So the appropriate setbacks from property lines, the water, density, height, etc.
Okay.
But again, when in doubt, depending on the size of it, always good to contact our building staff. And if providing a brief description of what you wish to build, they can typically answer the question quite quickly. But I have not seen building permits issued for those types of structures.
Okay. There's a unique one here. What about solar panels on the shoreline? Do they need permits to be there? Are there any prohibitions about having, because they're certainly going to be reflective, I expect, and they can be a little disruptive in their I would think, in terms of being able to reflect the light. So have you guys experienced that, and what have you done about that?
Go ahead, David. We did it at the same time.
Sure. Rob may wish to add to it. It's a good question. That's a tricky one. I know previously under it was called the Green Energy Act, provincial legislation did not allow the municipality to control or regulate anything that was designated as a renewable energy source under that piece of legislation. And this was likely about 10, 15 years ago now, and we were starting to see some type of that type of activity. Since then, we don't typically see it on the waterfront. That piece of legislation, I believe, has been repealed. And I would argue that, again, that would likely be a permanent fixture under our zoning bylaw. That would constitute a structure. May not need a building permit for it, but will need to comply with the zoning bylaw. I would argue it's likely accessory to the residential use, so would be allowed. However, should be subject to setbacks, so appropriately set back from the water, from neighbors. And there's currently no exemption in our zoning bylaw that says solar panels don't have to be 66 feet back from the water. So I think I would argue it has to comply with setbacks.
Okay. Here's an interesting one. I understand if you register your dock as a boat, you don't need a permit. Is that true?
Again, I'll stab at that.
Never heard of that one. Yeah.
Well, it
must be a floating dock. Yeah.
I haven't heard of being able to register a dock as a boat, but I believe what the inquiry may be getting at is vessels or watercraft are not subject to our zoning bylaw. They're not a structure, they're like a vehicle. And if someone has a license or has a registered watercraft, our zoning bylaws, I don't believe, would apply. It would be like any motor vehicle. I think the bigger question or hurdle or difficulty may be, are you able to get a license for said dock as a watercraft? That I'm not sure. I haven't seen that, but we do. You get the odd situation where a houseboat or that type of floating vessel is actually licensed, and in those situations, they essentially the municipalities' regulations do not apply.
All right, and there's I'm going to say inquiry, but more of a information session going on now with Ministry of Natural Resources around shipping container dock floating accommodations, which is kind of an interesting take on all that as well. So there's a question as well about how do you measure the shoreline frontage around the point? And I think I heard you mention earlier, David, that you're not taking it a straight, or it is a straight line, not a long line. So
that's correct. It's always a picture is worth 1,000 words, and if I had a number of diagrams, it would probably help, because as everyone probably can appreciate, there's endless ways or endless lot configurations in our township. But just a very simple point of land, what the zoning bylaw would say is you take a straight line measurement where your side lot lines intersect the water. So it will dissect or cut off the point of land potentially. You may be assessed at many hundreds of feet of frontage, but a straight line measurement where the two side lot lines intersect may cut across, and it may be significantly less. And hence really why I think we have the planning application process. Sometimes it's very difficult to write a one size fits all zoning bylaw that works well on every property. And you may be assessed and taxed on 800 feet of frontage, and yet our zoning bylaw says you have 50. And maybe that's a good candidate for making an application and arguing perhaps that I should be subject to slightly different rules than the 50 feet you've granted me. And that's what the municipality does, and we'll analyze that, and council will ultimately decide. But it will, the simple way to explain the measurement of frontage in a straight line is project your side lot lines to intersect the water. Wherever they intersect, take a straight line measurement between the two.
great. So I'm going to give you one last question, and it may not be that simple, but there's a number of questions that are kind of around the theme of a lot of us, we've had our cottages for many years. Mine was built in 55 a couple of times. Once it fell down and then it got rebuilt, and it's had some additions and the like. And I'm sure, and a lot of my neighbors have the same, they've been there for a long time, and the rules have changed over time. So you've got cottages or structures that would be non-compliant with today's rules. So how do you treat that? If I had to replace a deck that's that was there, and it's been there for years, do I get to replace it where it is, or do I have to now be compliant with the current rules?
It's a great question and a common one, and hopefully, you know, today's session helps clarify for some people and helps. And essentially, that's exactly right. Our zoning bylaws continue to become typically more stringent over time. We have many historical buildings in our township, many that do not comply with present day rules. It's a common term in planning circles, legal non-conforming or legal non-complying, and quite the common situation. And again, another exact reason why it's difficult to write a one-size-fits-all zoning bylaw in our township. And the main, I guess, main points I want to get across are the municipality cannot be retroactive. Those buildings, as long as they were built in accordance with the rules at the time, they're perfectly legal. They can remain. And the Planning Act actually prohibits the municipality from preventing an owner from maintaining it, keeping it there, and keeping it safe. So you can reconstruct it as long as it's in the same location, as long as it's in the same equivalent or reduced dimensions. You can put it back and obtain a building permit, even if it does not comply with today's requirements. However, if you're looking to relocate it, or if you're looking to expand upon it, or typically what we see in most cases is when a property owner is reconstructing, of course, they're looking to make it a little bigger. It is those enlarged or new portions that must comply with today's requirements.
Great, thank you. All right, we are going to wrap this up for tonight. It's all the time we have, and I want to have a special thank you for everyone for participating and asking great questions, and a special thank you to David and Robert for joining us. Your answers to our questions were terrific, and I'm sorry we had to limit your time because I know there's a lot more we could say on all these topics, but maybe there'll be a 2.0 version to continue this conversation. So if you want to read more, we have posted some resources here on the screen, and this will be part of the recording of the webinar as well. So just this event has been brought to you by the Muskoka Lakes Association. We are the oldest lake association in Canada, serving waterfront landowners since 1894. The Muskoka Lakes Association is a volunteer membership-based organization advocating for responsible stewardship and enjoyment of the unique environment of the Muskoka Lakes. Our priorities are to monitor, communicate, and advocate for Muskoka's natural environment, to advocate on behalf of all Muskoka property owners for responsible land use and reasonable taxation, to promote the Muskoka Lakes culture and give back to the greater Muskoka community, and to increase partnerships with like-minded organizations throughout Muskoka to advocate and educate collectively on important Muskoka matters. Every 4 years, we engage in municipal elections where every person and their spouse who owns a property is allowed to vote, even if it's not their permanent home. So just a reminder to go to voterlookup.ca to make sure you and your spouse are registered to vote. And we will be sending out more information in the coming months from the MLA, and we're aligned with the Friends of Muskoka on this work, to sending out information on how to vote and the candidates eventually who are aligned with our waterfront values. If you're a member, thank you for being a member and continuing to support us. Your membership makes it possible to do what we do. If you're not a member, I ask you what's stopping you. We have a wonderful organization and are certainly we're a very important voice with the township and working to make sure that your voices are heard with David and his colleagues as well. And one more thing to do before you leave is to complete our last 3 polls on the screen. We'd like to know if you thought it was informative, if you have any ideas for other topics that you'd like us to explore in the coming months. And you just scroll down if you haven't done so to the end of the questions. There's 3 questions there, and hit submit. And with that, just a reminder again that the webinar has been recorded. It will be posted to the MLA website for anyone to watch in a few days. We need some time to get it posted, and we will take the questions that were left unanswered and we will put them in a spreadsheet beside the webinar and provide those answers for you. So again, thank you so much for attending and hanging in with us to the end. We ended up with 181 at one point in the session. We're down to 121. It's getting close to dinner, so everybody's flying off. So thank you again, David and Rob, for your great comments and for joining us tonight. I really appreciate it. And thanks everyone for you joining us and making this a successful webinar. Have a good evening and stay safe.